there's this really interesting case that has created a lot of buzz throughout the United States, and it's an Australian workers' compensation case that deals with the issue of course and scope and business trips and exactly what is meant by the portal-to-portal rule. And I have blogged about it, I believe, 3 times in the April-May time frame. There's been all kinds of disagreement and spirited discussion about it on the Workers' Comp Analysis group of LinkedIn. And to borrow from one of my colleagues in Florida, Bob Wilson, it's the case that's been referred to as the blunder down under. And here's the factual scenario presented. And I'm not aware, by the way, of any case in Delaware that comes close to this. And given the amount of discussion with the national practice group on LinkedIn, I suspect there may not be another case like it in the U.S. What happened in this case is the claimant, a female, worked for the Australian government. And she was sent on a business conference far enough away, but still in Australia, that it required an overnight stay at a hotel. Without question, she attended all aspects and activities that had to do with this work-related conference. It just so happened that the particular town or location of the business meeting was one where she had a paramour. Who would have thought? And after the conference, this claimant and the friend got together and had some dinner and went back to her hotel room. And what happened next is really crazy. Maybe not unforeseen. If we had a foreseeability issue, I don't know. Maybe folks wouldn't be so much up in arms. But here's the thing. They got together. I don't know what to call it other than rough sex. But they engaged in rough sex, and this was one of those hotel rooms that I think we've all been in where there is a light fixture adhering to the wall over the bed. And the romantic activity, if you will, was such that her head kept banging the wall to the point where the light fixture was knocked loose and fell on her head, producing a closed head injury. Now, while some of us would probably just crawl away in embarrassment after something like that, this gal filed a workers' compensation claim. And it was denied at the Australian Commission level, and she then pursued an appeal. And here's where all the buzz comes in. The Australian court reversed the denial of the commission and awarded benefits. And what they basically said was, if she had been sitting in her hotel room playing cards with someone and had fallen out of a chair or some other mishap had occurred while she was playing cards, we would have covered it. So why shouldn't we cover this romantic activity? And so a lot of folks have disagreed with that result. Other folks have called the rest of us a bunch of prudes. I don't agree with the argument made by a lot of folks that the position against awarding benefits is fueled solely by the fact that she was having a clandestine encounter. I know for my purposes, I don't see this as being within course and scope when I look at it, because I don't think the risk of injury during rough sex is in any way reasonably related to a purpose or benefit of the employer, and I don't think it matters that it wasn't her husband, because some folks have said, well, I think you would all think differently and be more in favor of benefits if she'd been with her husband. I think that's a non-issue here, but there's been a lot of people getting hot and bothered about this result, and that has kind of prompted us all to look at, well, what would Delaware do for purposes of my blog? And I have 3 different posts about it. When I read the decision, I thought about a case, a Delaware case, that involved a worker that was sent to Puerto Rico for a business trip and sustained an injury in the hotel gift shop. And the Delaware board awarded benefits, finding that purchasing some sandals in the hotel gift shop, which is what occurred, was not a deviation, they looked at a deviation analysis, and they said that's not a deviation from the employer's purpose in having her there. There was a little bit of a but for. She wouldn't have been there but for the business trip. And further, there was some factual evidence entertained that the sandals were needed because one of her shoes broke, and there was a certain dress code, and she was among business colleagues, and therefore adhering to the dress code was important. So that kind of pulled that all into the work nexus, and benefits were awarded. So that was one blog post, and it prompted an email from our chief hearing officer, which usually when I blog I don't hear from the IAB. In this case I did, and he kind of jokingly said to me, "I'm surprised you didn't blog about horseplay as a defense." So that then prompted me to blog about it some more and look at the Delaware law of horseplay and revisit this issue, because, you know, one post about rough sex isn't enough. So we looked at some horseplay cases, and a couple actually from our Superior Court on appeal, and I came up with what I thought was kind of a troublesome result, because the one case that I looked at had to do with not a business trip, but someone coming to work, being wrestled to the floor. They worked in a warehouse, being literally mummified in duct tape and then locked in a closet. And the court, in looking at whether there should be a lawsuit in tort or whether it would fall under workers' compensation and then have the tort case blocked by the doctrine of exclusivity, the board found that there was no deviation from the work activity in undertaking this assault, if you will, on a coworker. I found the actions, from my conservative viewpoint, almost criminal, and I was very surprised that the court found that this was, I don't know, I don't want to put words in their mouth, but whether you want to say acceptable activity or foreseeable activity, but to hold that within course and scope, because I also don't think that's a risk an employer should have to bear, kind of like the rough sex. It seems to me that even though Delaware has always taken a very expansive view of course and scope, I've been in practice for 30 years, and I feel like I've seen that concept grow in the claimant's favor, and perhaps rightfully so. But it still seems to me that when we look at what's in course and scope, we should be looking at, is this a risk that the employer should have to bear? Now, sometimes horseplay is, for a lot of different reasons. We'll look at things like, was the claimant a victim of horseplay, or did they, you know, if they're a victim, usually benefits are awarded. If they're an initiator, then usually benefits will be disallowed. Not always, but often. So that was my second post, had to do with horseplay. And then another hearing officer had a reply to that one and said, well, you know, as long as we're talking about course and scope, right before I became a hearing officer, and he had joined the board from private practice, he said, I had an interesting case you might want to blog about that had to do with paintballing. And that case involved some gentlemen in the construction industry. The claimant was blinded in one eye by engaging in paintball activity on the job with coworkers. And admittedly, he was hit by a coworker. The evidence, however, suggested that the claimant was not a victim, that he was the initiator, that he was the aggressor, and that he came to work with all of the paintball apparatus in his truck for that very purpose. In that case, the board denied benefits. And that seems like an appropriate analysis for me. And I do think that's a lot different, for example, than the gal that's in the islands and has a mishap in the hotel gift shop. So that was sort of my tribute, 3 posts and 1 whole week of discussion to the blunder down under, also known as the Australian rough sex case. And it was a lot of fun. There was a lot of puns. I think one of the one about horseplay, that post, if you're looking for it, is titled A Roll in the Hay. And I think the paintball one is titled something like Paintball and a Little Rough Sex. So it's created, though, from an esoteric standpoint, just a lot of thinking about how would we handle this, because it's not something we've seen. Maybe it's something we'll never see, one would hope. But they apparently have a very generous view of course and scope in Australia. Or as I would put it, a woman's work is never done.